Hello, everyone. We're going to start joining people, and I'm starting to gather all of these horror story emails. Man, there are a lot of them. I can't wait to hear more. And then we'll analyze legally what, if there is a legal argument, what those legal arguments might be. Thanks again for your patience from last month. So I could attend to a family matter. Y'all can see my screen. How many of you have received photos like this in your emails? Because you sent out a weed violation. Oh my. All right. Well, welcome everyone to today's Learn at Lunch. Today was going to be a recap of last year's crazy stories. I know we've gotten a bunch of those. I don't know. I don't think I could do justice telling the story that you guys have sent in. I think it might be better coming from you. So if you wouldn't mind sharing your story of the worst thing that's ever happened to you, or the craziest thing that's ever happened to you as an HOA manager, I would love to take you off mute and you can share that with us. And at that point, we can talk and analyze the situation and how we can resolve it if that is possible from a legal standpoint. So if you don't mind, could you just quickly put your name in the chat for everyone, and then I'll take you off mute as we go. As I'm waiting for those chats to come in, I will share a few of the craziest rules that I've ever seen that are just nuts. So, and these are rules not only in Arizona, but from articles for HOAs across the US. If you've been managing for any while, you may have heard a few of these before, but I guess I'm stuck on this series on Netflix. Have you ever heard of The Secret of Skinwalker Ranch? A few of you, yeah, some of you have seen it. I just binge watched all 3 seasons. It started off rough because of I don't know, they just weren't acting correctly or whatever, but that's the Skinwalker Ranch is a ranch in the Uinta Basin of Utah. It was it's been known for hundreds of years to be the site of UFOs and werewolf and all sorts of weird anomalies. And so it was purchased by a billionaire Bigelow, who started, who basically partnered with the federal government to investigate the aerial phenomenons and UFOs and UAPs. And they did all sorts of experiments that are even to this day classified. Well, Bigelow sold the property to an individual who then opened it up and had a bunch of scientists come on site to the ranch and do a bunch of experiments. And it is nuts, some of the stuff that happens. The last one, apparently there's maybe a UFO underground. They dug about 400 feet underground and obtained metal shards. But the reason why I'm bringing this up is because there's an association in Alabama that had passed a rule that it is illegal to feed Sasquatch. Have you ever heard of this one? Have any of you? It was actually, when you look at the article, now I'm not familiar with any of the board members from this rule that they adopted, but I did watch the news article on YouTube, and I did see the report on it. That an individual in this community was being fined for feeding the skunk ape. And they did an interview, and this guy in the deep south is like, I ain't know why they fined me for feeding the skunk ape. There ain't no such thing. And this community board had adopted a rule that you cannot feed the skunk ape. Apparently you can feed mountain lions, you can feed raccoons, but you can't feed the skunk ape. So I thought that was hilarious. Anyways, I don't see anyone putting a chat in there yet. So I guess I'll just share these stories for now. Okay, so if you joined me, you saw that first photo of that individual flipping them off. I'm going to read this email because as part of our emails out to all of you to share your worst stories, basically you gave me permission to read your story. So I'm going to read them. All right. Oh, Mandy, you're going to go. All right, perfect. I'll unmute you. There you go. I'm asking to unmute.
Oops. Okay. Okay, so I have this crazy one that's undergoing right now that I sent to you. We actually met up with Mark Saul yesterday in legal. So currently right now we're dealing with this guy. I'm assuming he's the owner's son, but we're not too sure. He's already kicked in this lady's door. I think there was probably like 12 people that signed on to my meeting last week and said that they're scared to death of him. He is doing like welding and all kinds of crazy stuff on the patio. He has a pit bull that he doesn't keep on a leash that attacks people. It's pretty
That
bad.
actually attacks people.
According to them, yes. We don't know yet. I'm putting up more cameras. Like I'm trying to expedite that as fast as possible. I do have some videos. I have videos of obviously, you know, sparks flying. I contacted the police a couple days ago and they refused to do anything until the building catches on fire. Yeah, I'm not kidding. I have that documented too. I should have recorded it. It was crazy. I contacted the fire marshal too to see if he's like against any codes, and I haven't heard back yet. So we're gonna do another cease and desist letter before we take him to court. Nobody wants to step up to be a witness, so I'm the witness.
All right. Wow, that's a doozy. In what I'm wondering is in this post-COVID world, I actually read an article. I can't remember if it was who wrote it, but they talked about COVID brains and how COVID has clouded some people's brains. And when I had COVID, I've had COVID a couple times now, despite getting the shot. But anyways, that's another story for another day. But I remember, man, I felt like I was in a cave, and I just felt like my brain was operating on about 10% capacity for a good week. And there have been articles written by well-respected folks that COVID brain's a real thing, and it can be a long-term effect. And I wonder if COVID accelerated craziness, because we're dealing with a whole lot more crazy when you're dealing with isolation, human isolation, COVID, and all this other stuff. You're dealing with social media. You're doing a whole lot more crazy today than even from 2019, 2020.
Mm-hmm.
So here's a couple of things that I wanted us all to address, because this scenario is kind of like a perfect storm of all sorts of problems rolled into one guy. So you have
she wants me to be her bodyguard.
Yeah.
I was like, he's not gonna kick in my door, no. I'm not gonna go around you, lady.
So you have this guy welding on his patio, throwing sparks out into the community. Okay, you have his pit bull running around, apparently attacking people off leash, and you have him harassing everyone and yelling and screaming, right? Anytime.
Yeah, and his 3 junk cars that he parks in handy. I mean, it just goes on and on. It's nuts.
Junk cars. So he's also parking all sorts of junk cars in other people's spots.
And jet skis.
Let's talk, and jet skis too. Okay. Yeah. Awesome. Is this a condo?
Yeah, signature condominiums.
Okay.
Off of Thompson Peak.
Yeah. Wow. So, quick caveat, and that is, because we're all here together having a group discussion, this can't be legal advice, right? But having said that, I mean, you've already got the association's attorney that's addressed these for you, for outlining specifically for you, but let's have a group discussion about this. This is my thought. When you come to me about this type of situation, there's several things that I like to talk about. Number one, we always think about the police department when you're dealing with people like this. the one thing that I want to do when I'm dealing with something like this, I don't know if you guys have, but I want to reach out to the community action team officer. Every single police department has a community action team department. Some of them call it something else, but when I was with Mesa, it was called the CAT department for community action team. And there were specific CAT officers. I know Mesa still calls it CAT. Phoenix, where is this Signature Condos? Is it in Scottsdale? Yeah, I thought so.
Yeah.
So yeah, with Scottsdale, they have the exact same thing. Basically, they are police officers that have promoted from being beat cops to working in the community action team. And they're assigned to work with apartments, condos, and neighborhoods. That's their whole job. What I find typically is if I were to call the non-emergency line and try to work from bottom up, I get deaf ears. But if I go from top down, it's much more effective for me to talk with the community action team officer and then have them talk to the sergeants over the shifts for days, swings, graves. And boards can and do meet with community action team officers. So in these types of scenarios, and this isn't just for you, Mandy, but I think this is for everyone, it's very important to involve the police department. And frankly, I think with all of these factors that are outlined, if a community action team officer were involved, you may have a much better chance of that officer helping to have the police department investigate this. And frankly, they can also call the fire department. I know when I was an officer for Mesa, we would have some of these happen. I never was a CAT officer, but I know that I would involve CAT officers the second I'd go out on site for like a condo or something like this, or an apartment complex, and there'd be a problem. I'd like, okay, there's nothing I can do as a beat cop, but I'm notifying the CAT officer to work directly with the manager for the condo. And in a fire hazard situation, they would definitely work with the fire department on that and code compliance with the city. So I think that there's more you can do potentially with the police department. And I don't know how much of a conversation you had there, but I think you got the civil aspects that the HOA attorney can handle, but it's just civil because we don't have jurisdiction over the criminal side of things. Title 13 is the criminal statutes for all of the different ways that there can be criminal violations. And that's where the police department comes in. And I think there's several criminal aspects to this that could potentially be explored a little bit more. So that's especially important when you're dealing with somebody that's very scary and all the owners and residents like, I don't want anything to do with this because I don't want retaliation. I don't want to get shot. I don't want my car to get egged, whatever it might be. So that's number one on this specific issue. Number two is, I'm sure that you mentioned Mark already met with the board, but I'm sure this came up, and that's injunctions prohibiting workplace harassment. So for those of you that may not know what that is, if I'm a creeper, my wife would call me a creeper right now because I'm wearing a mustache and trying to grow it out. And she doesn't like it. But let's just say I'm the creeper and I'm texting you and I'm following you around. I'm sending you photos of when I'm following you around. What can you do to get me to stop doing that? You're going to go get an injunction prohibiting harassment against me, a protection order that says I can't text you, contact you, harass you, come within 50 feet of you, whatever it is, right? If I ever do after that, once I'm served with that order, guess who's getting arrested? I am. That exact same type of option applies and for community associations. But it's called an injunction prohibiting workplace harassment, because that not only applies to the workplace for profit companies like businesses, but nonprofit businesses, nonprofit corporations, which include community associations. So it's a pretty easy process, actually. Pre-COVID, to get an injunction in the Superior Court anyways, took a very long time. But if you get one in Justice Court, they're signing a whole lot more of these today because there's a lot of more crazy today than there was even 3 years ago. So it's typically a telephone call or a Teams meeting or a virtual Zoom meeting with a judge at the justice court. They're on the phone with the manager, with anyone that may be willing to serve as a witness. And if there's harassing events, then you have that aspect. With the pit bull running loose, if that pit bull's indeed been attacking people or being aggressive, that's something that needs to be handled immediately. I just had an insurance defense case we had to settle literally a couple months ago, where a pit bull, it wasn't a pit bull, I think it was a hybrid dog from years and years and years ago, 5 years ago, attacked another dog. Animal control came out, didn't do anything about it because it's dog on dog. But then fast forward to 2 years ago, that same dog came and attacked another animal. And when the two owners tried to come separate the dog, guess what happened? That dog turned on both of them. I've talked about this one in these scenarios before, and you've probably heard me if you've been in any of my classes talk about this specific example. But the personal injury attorney sued somebody. Who did they sue? They sued the owner of the animal, of course, but they're always after the insurance money, right? I just got off the phone with my neighbor from yesterday, who is the personal injury attorney, asking him about a specific other situation for one of my boards. And he's like, oh yeah, in that scenario, I'd sue the HOA every day, all day. I'd love that case. When it comes to dog bites, though, it's strict liability. PI attorneys love dog bite cases because it's strict liability. One, in this scenario, the HOA knew that this dog was, or at least it was foreseeable, this dog was dangerous because it had already attacked somebody. And the HOA's defense that, hey, we didn't remove the animal because animal control didn't remove it, didn't go anywhere. Insurance paid the limits on that case. And luckily we were able to settle it for just the limits because the damages weren't significant. Like when I say significant, I'm talking about millions of dollars beyond the limits. Let's say in this case, both people that were attacked were fine. I mean, they went to the hospital, they had some stitches, and there's some permanent scarring, permanent disfigurement. Okay. But what if they attacked a toddler in an upscale community where the two parents were very successful? One of them is a neurosurgeon and one of them is something else. Now, from a quantitative value perspective, that's a very big case. And my PI attorney friend said, not only would he get the limits, but he'd sue the HOA for the additional damages and get a judgment against them for the additional amounts, which would mean if that happened, let's say that he got an additional judgment for an additional $5 million because that toddler dies. What are you going to have to do then? You special assess every unit owner the amount of that, their pro rata share of the judgment. So it can be very dangerous. So I'm hoping, and I would imagine, that you're addressing that issue as well. And I assume you are because you're dealing with a great attorney. So, okay, let's see here. What is the risk of CCW for managers? Concealed carry weapons permit, right? Is that what you're asking about, Paige? Yeah, that's what I thought. Okay, so let's talk about that in just a minute. April, I'll get back to you in a second. So let's talk about this scenario. Mandy, let's say you're going on site and you don't tell your boss, but you carry a weapon because you have a CCW. And this cat approaches you with a knife because he's an idiot. Are you justified in defending yourself? Yeah, you are. The scary thing about in Arizona, at least, let's just talk about Arizona. You don't need any kind of permit to carry concealed. You can't obviously carry concealed into areas where it's clear you can't, like government buildings and things like that. But if you're carrying concealed anywhere you're authorized to carry concealed, you don't have to have a concealed weapons permit. And I carry concealed quite a bit because I feel naked without a gun. But at the end of the day, if I shoot someone, there's going to be 15 different people analyzing that shooting for the next 10 years after the fact. Some of those people will get where I'm coming from. Others will not. Let me share with you, as a police officer, one of my situations that I had. I don't think I've ever shared this one in a mass setting like this. But being an officer is not safe sometimes, right? I mean, every time you put your bulletproof vest on, your heart rate jumps from 70 beats a minute to 120, and it doesn't go down below that until you take your vest off, especially when you're working swings or graves. But I had a situation, 911 was called. There was an apartment complex in my beat where an individual was going around the community in this apartment complex. He had a Glock, and he would rack the Glock, slide back, and he would walk around, and anyone he'd see pointed at their head. And then he'd walk to the next person. So when that happens, we had multiple people calling 911. We didn't have anyone say the shots were fired, but this kid was walking around pointing it at every single person he could see. And sometimes it was long distance, sometimes it was close range, like literally put it up against the person's head. Or as they were running away or whatever, trying to put it up against their head. Super scary scenario, right? I'm hoping none of you have ever had this situation happen in any of your condos, but I'm the closest one on scene. When this kind of thing happens, 911 is called, obviously, and 911 dispatch, at least in Mesa at the time, and I think they still do it this way, they hot tone it, which means they do 3 beeps, beep, 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 and then that means every officer shuts up on the radio, and they designate that one channel for that one call. So 911 operators then go to different channels to work with other officers. That one channel on the radio is for that. And so there are multiple officers responding to this one. I'm first on scene. And luckily, one of my beat companions, who was the officer next to me at a different beat, was pretty much right behind me. So I pull into the apartment complex. I immediately see this kid, and he points his gun right at my car. As I get out, I jump out. I jump behind my engine block. I pull my gun out. I point it right at him. As I'm pointing at him, as he's pointing at me, he's about 40 yards away from me. As an officer, am I justified to engage him at that point? Yeah, absolutely. He's pointing his gun at me. I felt like I had a relatively safe position of cover, but my head is exposed. At least this part of my head was exposed. And he's pointing his gun at me. Do I know, number one, if that gun is loaded? No. Do I know, number two, can I reasonably justify in that scenario that I am in a life-threatening situation that could cause serious bodily harm to me? Yes. If I pulled the trigger and I put him down, that's a justified shooting, in my opinion. Regardless of whether, I'm going to tell you what happened in just a minute, but at that point, if I had pulled the trigger and put him down, obviously I'd have to turn in my duty weapon. There'd be this big investigation in that justified shooting context. This is a pretty clear example. Now, obviously, the water gets much muddier when there's not a gun involved, there's a baseball bat or something else. But in this scenario, it's pretty clear if I pulled the trigger, it's a justified shooting under all the training and everything that I was trained to do. And I wouldn't go to jail. As I'm put my finger on the trigger to start pulling back to have that weapon go off, I'm observing my surroundings, and directly behind him is a kitchen window because he was standing on the grass. So I pull in the parking lot, covered parking. He's underneath, he's on the grass behind the covered parking lot, just about 2 feet in front of a wall of the apartment complex. And there's the kitchen window right there. And in that kitchen window, I see a mother and her child that she's holding in my line of sight. So now I'm thinking, I took my finger off the trigger, put it back straight along the frame, because in my mind, I'm thinking, if I pull this trigger and that bullet goes through him or misses him, I have a chance of hitting that mother or her child. And I was in a position of relatively safe cover. It would have been hard for him to hit me because he had his gun all over the place. I could tell immediately that he wasn't in the right mind just by the way he was acting. So I took my finger off the trigger. But my buddy, who was right next to me, we had flanked him. That's what one of the tactics as officers. One of them keeps the person's attention and the other one flanks. So I had no idea that my buddy, companion officer, was flanking him, and he put him down because he had a much clearer line of sight. So in that scenario, if I had shot him as a justified shooting, and for whatever reason I had injured that mother or her child, would the city of Mesa get sued? Absolutely. I mean, it's pretty clear. Even with the justified shooting, there's collateral damage, and the city of Mesa would be sued. Could I personally be sued? If I'm acting with reckless disregard for human life, maybe, maybe not. But in these high intense adrenaline moments, a lot is going on. But I had, through my training, that the peace of mind of, or at least the thought of knowing, number one, I'm relatively safe here. He wasn't actively shooting at me, so I took that split second to take my finger off the trigger while I knew exactly where my companion officer was and where he was positioning himself to take that suspect or that individual down and neutralize the threat, which is what happened. So if you, as the property manager, are carrying concealed, authorized to do so, you just have to understand, if you ever use a weapon, you just don't know how things are going to go down after that. I don't know if you've seen the Instagram post from a couple days ago, but there was an altercation. I don't know if this was in Chicago or New York or where it was. I don't know if any of you saw this altercation on Instagram, but there were two guys that were in a fight. One of them standing right here, and the other one standing right here. He's standing sideways to him. He goes to pull out his gun to do this and shoot him. And this guy standing here grabs the hand, moves it over, and with his other hand, this one, takes his gun, shoots him twice here, boom, boom, right? So this guy starts, takes out his gun to do this. This guy grabs hand, put it right here. And then if I'm this guy, with my free hand, because this one's grabbing his hand, right? I pick this up and I go boom, boom. So when that happens, this cat, meaning me, getting hit right here, fall down. And then in the heat of the moment, for whatever reason, after this, I'm on the ground. The guy that shot him stands over him and empties another 7 rounds in the guy's back and head. So the question here now is, and the quote and headline on that was, is that murder? Some of you shake your head, yes. But having been in these situations, I can tell you from firsthand experience, and all the research backs this up, when you are in that kind of a situation, you could pull the trigger thinking you shot twice, but when the investigation starts, you realize you emptied your entire magazine, and you only thought you shot twice because your heart rate gets elevated, the fight or flight response kicks in, and your mind goes into auto drive, where your mind just skips ahead sometimes, where you don't recognize what's going on. So I don't know if that cat, after the 2 shots, realized that the threat was neutralized. And this is going to be something that's going to be litigated. I'm sure he's going to get sued. I'm sure that the police department is going to investigate whether they should impose criminal or that they should charge him for manslaughter. It's not murder because it was heat of the moment, right? It's not like he had thought about killing him in advance. Maybe he did, I don't know. But the bottom line is, it's a heat of the moment kind of thing. And I think there's a very good chance he'll be charged with manslaughter in that scenario, because once the threat's neutralized, you need to back off. So once this guy fell down, if he had just stayed there with the gun pointed at him, okay, cool. But walking over there, hitting him, and he like clocked him, boom, 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 boom. And then he put his, and then he like took around like he was like the man for doing that. Those signs show me this guy, A, probably has killed somebody before, and B, had no remorse over doing that and knew what he was doing. So I'm thinking he's going to get charged. But I'm just telling you, if you ever are in that kind of scenario, you have a weapon with you or whatever, one, I would make sure my company knows, because if you do shoot somebody on company time, your company's going to get sued, most likely too. And number two is, you just have to understand, one, you have to live with the consequence forever, which can be detrimental to your emotional state, or you can get over it. Sorry. I guess there's a reason why I had to leave the police department. But anyways, going back to this, that you have to live with what happens afterwards, because taking a human life is never fun. And then on top of that, you have to worry about the civil liability that comes with taking human life. So my recommendation to folks, anytime they ask me about carrying weapons on site, yeah, you have to do what you're going to do to protect yourself. And despite the fact that the cost of killing people, justified or not, does come with an emotional burden, I still do it because I know that I'd rather be breathing than some idiot that's either puts my health or my family's health or somebody else's health in jeopardy. And I'm okay living with the burden of what that is. But for you just have to understand, if you are not trained to use that weapon and you just have one carried around, that could be a real big problem. I'm sorry to dwell on this so much, but that's anyways, that's my comments on that. Going back to the next one, April says, I have a similar issue at condos I manage, but the guy uses a leaf blower on his patio in the middle of the night. Nice. Nice. Middle of the night is in like midnight, 1 o'clock, 1 a.m., 2 a.m. Can you imagine that? Guys using a leaf blower on the patio at midnight or 2 in the morning. There's been domestic disturbance issues. So are you saying, April, that he's been abusing spouse or kids or something as well, like fighting or?
Yeah, so the neighbors say that they're fighting at all hours of the night. They've called the police on them. But again, like, the police come and there's really nothing they can do. It still continues after they leave. So
Yeah, so this goes back. I mean, question for you on when you look at these noise disturbances, well, obviously operating a leaf blower, that's not a question, right? He really truly is doing that. Nobody's disputing that, right?
correct.
Okay. So how many people in the community are complaining about this cat?
All of his neighbors.
Okay. So on a scale of 1 to 10, when you're dealing with noise disturbances and things like this, so yeah, leaf blower, you have domestic violence, so he's yelling and screaming, pounding on the floor, the walls, whatever, right? And he parks in the fire lanes, blocking emergency access. Scale of 1 to 10, when you're dealing with, let's talk about just the leaf blower issue that's disturbing, and all the banging around and domestic violence. On a scale of 1 to 10, whether the association should get involved, 10 being over here for the association needs to get involved, 1 being neighbor to neighbor issue. If it's just one homeowner complaining about noise, I think you're more over here on the spectrum. If it's everyone complaining about noise, you're over here. And I've actually had judges order that's a violation of the nuisance provisions when you're dealing with massive amounts of noise that keep people up at night. So from a legal perspective, if the association tried to get an order against him to stop blowing his leaf blower and be quiet, you're going to get it. I'm not worried about that part. You're going to get that injunction. It's a question of whether the judge awards you all those attorney fees. Because, yeah, go ahead.
I've actually had people move because they couldn't take it. I guess he goes and confronts the neighbors about it, and people are fearful of him. And again, he's only a tenant,
Yeah.
but the owner is his brother. So the owner is not going to do anything about it.
Well, I think there's a couple things, options that the board should be considering. Well, number one, is getting an injunction prohibiting workplace harassment. That's number one, so that he does get arrested when he harasses everyone. I'm not saying this is exactly what I'd recommend because I can't give legal advice. I want a little more facts, but I'm just going to give options here. Number one is injunctions prohibiting workplace harassment, right? Number two is fines after you do the standard enforcement policy. Number three, involve law enforcement, especially for the domestic violence issues, to the CAT officer. Number four, on fire lane parking. I don't know what the rules and documents say about this condo. I assume it's a condo because you're saying patio and it's
Yes.
closed shared wall area. So there may be tow authority, start towing vehicles off the fire lane area so that you can keep emergency lanes open and available. That may in itself kind of kick the wasp nest a little bit, but this owner has to understand he has to control his brother. We already have under the Condo Act 33-1260.01. It says that the landlord shall abate all criminal activity on the land it controls, he or she controls, or he or she controls. So I don't think this behavior is something that should be allowed to continue. The bigger question is, how do you attack it when you have a family relationship? And is there a way to do that without incurring a lot of attorney fees? And like I said, the first place to start without the attorneys is the community action team officer and having a good relationship with the CAT officer. Any other comments about this scenario? I mean, have you had to deal with this, and have you successfully been able to resolve it? Anybody want to venture to let her know what you did to get that resolved? Okay. Well, we obviously, as your attorneys, have these come up all the time. Like I said, injunctions prohibiting workplace harassment is kind of the nuke button. But we have had significant success dealing with the CAT officer, sitting down with them, talking with them. I don't know if I try to use my connections anytime I possibly can to get a CAT officer to chat with me because he knows I'm formal law enforcement. And that really helps, goes a long way. So that's number one. Number two is from just a pure civil perspective, everyone should have the ability to fine for violations. And in this scenario, there are a couple of pain points. I haven't mentioned recording a notice of violation from a civil perspective, but you can also do that. It looks like a lien, but it's not a lien. And it basically just says there are violations in play, and you record that on the unit, you send that to the owner. Sitting down and having a conversation with the attorney, having a phone call with the owner, and letting them know, I do this, letting them know exactly what could potentially happen if they don't control this situation, and if it does get out of control. But again, is it foreseeable that this individual could harm somebody else in the community? And if it is, and they do, it's a given that the HOA is going to get sued. The condo is going to get sued. It's just a given. It's going to happen. I mean, I just know it is, because like I said, my neighbor's a PI attorney, and he sues anyone and everyone he can when there's an injury. All right. Yvette says a person who lives in a high-rise condo is reporting toxic fumes that no staff or other neighbors can smell. She is convinced that her neighbors below are smoking something in their unit, but we can find no evidence of what she is reporting. She had submitted a doctor's note that states she has hyperemia, anyways, and that the fumes are negatively affecting her health. She has been complaining of this since September, but also refuses to complete a violation form against her neighbor. Yvette, I'm really glad you put this in the chat box. Why? Because in this example we're talking about is that spectrum of 1 to 10, right? That scale. And when you have one person complaining about these fumes, maybe there are fumes entering the unit. But I think that's more of a neighbor thing at this point. What happens if this owner dies because of the said fumes? Is a PI going to sue the condo? maybe. But at the end of the day, one, you don't have any evidence. Two, she's not willing to submit a complaint form. Three, short of you actually setting up equipment to actually quantify what fumes are being emitted, if any, what else can you do? I would tell her to keep calling the police department for these fume scenarios, or fire department, code compliance. It doesn't even sound like she's explaining what type of fume she's talking about. Just says, excuse me, just says toxic fumes. So I don't know if this lady, it sounds like this lady's crazy, or at least I would just say that's one option. She may be nuts, right? In the law, people like that are called eggshell plaintiffs. Eggshell meaning it's really easy to crack them. And in the law, an eggshell plaintiff is the legal way of telling a judge this person doesn't have a case, and any injury they're suffering isn't like millions of dollars. It may be like $5 or $10, if anything at all, because they're considered an eggshell plaintiff. Okay. So that's great comment. A couple of mustache comments, thank you. Friendly, Mandy, you asked, so friendly fire doesn't count then? They say that in the military, right? Friendly fire resulting in collateral, right? What happens on the battlefield in war is there are a different set of rules of engagement there. And it's a lot different than the aspect of domestic, I'm going to say warfare, domestic warfare, because that's really what it is here. But it's not really warfare, it's domestic confrontations. And friendly fire absolutely can result in civil liability. Here in the States, for police departments, for the FBI, when they engage internally on the homeland. Internationally, during an actual war, in an actual war zone, if let's say a Marine shoots and kills somebody point blank when they enter a house, they can be court-martialed. They can be prosecuted and go to a prison for the rest of their life. And there are incidents like that happen, but it's a different set of laws. And you probably have heard of JAG attorneys. JAG, those are the military attorneys that look at prosecuting military individuals for violating military laws or international laws. So yes, it can happen and does happen. But again, it's a wholly different body of laws. But friendly fire here in the States, if I had pulled the trigger, like I said, and it had gone through this individual and then went into the wall and hurt that mother with her child, it just is a function of what's going to happen. Or if I'd shot and missed because my adrenaline's going or whatever, and it hurt somebody, I'm going to get, City of Mesa Police Department would get sued for that, for sure. Would I get fired? Maybe. Would I get sued personally or go to jail personally? In that scenario, probably not. But we've all, in the recent past, have seen officers that have gone to jail for using excessive force in various scenarios, some for murder, some for manslaughter, some for negligent homicide. So it's definitely a possibility. I don't want to focus too much more on the cop thing because there are a lot of other examples here we can talk about. Okay, here's another example. This was submitted by Lily. I didn't see you if you're on, Lily, but I'm going to read this. This is the one that we started with, where there was individual flipping off. So basically, in that scenario, you have a yard that's just completely toasted. You have weeds everywhere, grass overgrown, and you're just dealing with an obstinate homeowner. The email here is pretty long, but I'll just start it. I'm going to send you pictures randomly that I have proof that when it's too much wind out here and we have trash in our yard. Oh, this is, by the way, yeah, email from Lily to me. Lily, are you on? I don't see you on. I had a question for her.
I believe this was the email from the resident or homeowner.
Yeah,
It
that's
was
what
like
it's,
one long run-on sentence to Lily.
yeah, that's what it looks like. Are you familiar with what happened?
I know, I just read the email.
All right, okay. Let's see. I did not purchase that, and I will send pictures of random reads that you don't have to send me. Fine, because you come once a week and you don't realize how much things are different every day. What are you, a complete B? That you're overcharging us, you're excessively charging us. And I've also talked to neighbors, and I know you're doing this to everyone. It is harassment. You're just a complete B. And she uses the word B here about 25 times. We've all seen these emails from homeowners or tenants or whoever. In that email, she attached not only that picture I started with, where she's flipping the manager off, but she also submitted, for whatever reason, a picture of her, I don't know who it was, in the hospital with her next to him, maybe to invoke sympathy factor of, hey, I'm dealing with a lot here. So what do you do when you have somebody that's harassing you via email? Is there anything in the law or any case law that allows a manager to get any type of protection from homeowners that are harassing them, either yelling or screaming at them or using profanity? I see some of you shake your head yes. Have any of you, here's the question back to all of you, have any of you ever seen a judge order an owner or a tenant or whoever to stop emailing you? It's out there. We get those occasionally as part of that injunction prohibiting workplace harassment scenario. But you have to be careful when you go to a judge, because an email just complaining alone is probably not going to be enough. You have to prove harassing events. So a manager last week went on site, and the resident, who happens to be transient, so let's say there's this email calling you a B and everything else. You get on site during your normal weekly compliance, and this same individual starts following you while you're doing your code run through the condo. And not only are they following you, but they're acting like James Bond, ducking behind bushes as they go. So you turn around and they're standing there on the sidewalk. You make eye contact and they dive behind a bush. Well, number one, that demonstrates that they're a complete nut job. But number two, what else does it demonstrate? They're an unstable person. But you continue to do your code compliance, and they continue to follow you, keeping a distance of about 50 feet or so, 50 yards. But they're always tromping through the bushes to try to hide themselves. And when they are visible, if you make eye contact, after making eye contact, they dive behind bushes. What do you do in that scenario? Is that enough now with this email and them following you during code compliance to get an injunction against harassment against them? Are judges going to do that? Any of you ever see that happen? I'm going to say yes, because we've got several of those at any given time. It takes us about 2 hours to get an injunction prohibiting harassment under those exact same scenario. And when they get served for that injunction prohibiting workplace harassment, and they try to go to the court to quash that injunction, I've never had a judge quash the injunction, because they're following you and they're diving behind bushes and they're acting unreasonable. That's one event. But the second event is that's combined with the emails, the abusive emails. And that's enough. I've never seen a judge not sign an injunction prohibiting workplace harassment in that scenario. And like I said, after that injunction's been signed and served on that individual, at your next code compliance run, if they do the same thing, what's going to happen? They will get arrested. The officer has to arrest, because the judge is ordering that individual not to do it. And the police department must enforce judge's orders when the order involves criminal aspects, and the court is ordering that the police department essentially arrest when there's a violation. So that's how I deal with that a lot nowadays, is these injunctions prohibiting workplace harassment for active scenarios where there could arguably be a health and safety issue. All right, last one. We're running out of time, but last one. We have a code of conduct rule. if a member yells at or harasses staff or another member, the association will send violation with an instant $150 fine. Is that going to work? And I'm going to say, maybe. Let's analyze the legal aspect, because the statute allows imposition of a fine, quote, after what? After notice and an opportunity to be heard, the board may impose reasonable monetary penalties for violations of the community documents, end quote. So let's analyze that. What are the requirements for imposition of fines? After what? Number one, notice, and number two, opportunity to be heard. So can I arguably impose a fine? Is notice arguably given when a resolution is adopted saying, if you do X, there's going to be a $150 fine? Yeah, I think so. And I think most attorneys are going to agree with me on that. The bigger question for all of us is, what about this opportunity to be heard? If this owner gets the $150 fine and then retains DeSaulles to send a demand letter, what is DeSaulles Law Group's argument going to be that the fine is invalid? Because I've seen this before when there's automatic imposition of fines, as have my colleagues at other firms. It is, even if notice was previously given. Number two, where was the opportunity to be heard? Now, some attorneys in this HOA space will say, okay, if you impose the automatic fine, when you do send the letter, say the $150 fine has been assessed, period, on your account. You can have an opportunity to be heard, and we will retroactively waive the fine if there's a finding of whatever. But you have 10 days to whatever, 21 days or whatever, to reach out to us. Is that enough to satisfy the statute? If you impose the fine and then give them the opportunity to be heard right concurrently with notifying them that the fine is being imposed? From a strict contextualist point of view, it doesn't comply, because again, the statute says after notice and after an opportunity to be heard. It doesn't say concurrent to the opportunity to be heard. So I think there's a very good argument to be had that the automatic imposition of a fine may not legally be justifiable if it's ever litigated. I don't know of any DRE cases on this subject and what the DRE judges have ruled. I know at AACM they have that law updates class that we teach every year where all the DRE cases are summarized for the last several years. I don't remember any one of those DRE matters that we've taught over at AACM that analyze imposition of automatic fines. Because probably the fine's been waived anytime somebody like DeSaulles raises the argument. Then that's probably what I'm going to tell my board, is it's going to cost you a lot of money and you don't have a very good argument here. You got a good faith argument, but it's not great. So what do you do? Automatic imposition of fines, if you're going to do it and it helps, go for it. But I'm just saying that the caveat here is if it's challenged, chances are it's not going to be upheld. But again, there's other things you can do in these scenarios. If the board feels like there's a need for an automatic fine, there's obviously potentially health and safety issues with that, especially in this scenario where there's harassment. And like I said, there's other options too, which we talked about today. Well, everyone, thank you so much. I hope you enjoyed today's class. It was recorded, so if anyone missed it and you want to review it or have them review it, let us know. Admittedly, because this was one of those customized classes that we put together based on your comments, it's not CMCA approved yet, but we're gonna try to get it approved. And if it is approved, we'll send you credit for this specific one. So I look forward to seeing you at the next one. I'm excited to continue, and we'll see you next month. Thank you so much, everyone. Bye-bye.